if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath
I'm not sure what that is.
in regards to the right to travel under the 14th Amendment?
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
Next, Judge Perkins steps in to clearly lay out why the court unquestionably holds authority in this matter. He breaks it down in plain terms, addressing the argument calmly but firmly. The explanation leaves little room for confusion, showing how jurisdiction applies regardless of personal labels or theories. It's a straightforward legal lesson that cuts through the noise and brings the focus back to established law and procedure.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was, Mr. Glenn.
Yes, it is, sir.
To close out the week, the spotlight turns to a courtroom scene that quickly spirals out of control. A visibly agitated defendant loudly threatens legal action against the court if the case moves forward. Her warnings come despite clear explanations of the process and the charges involved. The moment highlights how emotional reactions and misunderstandings of the law often collide with the structured reality of the justice system.
So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court's time.
I often remind people that showing up to court in a clear and focused state of mind is critical, but that advice is rarely taken seriously. What follows is a perfect example of how poor judgment can quickly make a bad situation worse. Let's slow this down and explain what is actually happening here, because the person involved is doing real damage to his own case. If he had paid attention to the friend of the court, he would have heard something important. Yes, the court acknowledged that he was behind on child support payments. However, the official also clearly stated there was documented proof showing he had been actively trying to find employment. That effort mattered more than he seemed to realize, even though he hadn't secured a job yet. The court viewed his attempts as a positive sign. Judges often consider effort, intent, and cooperation when making decisions. Unfortunately, with one impulsive and reckless outburst, he managed to erase much of the goodwill that had been built on his behalf. And the situation doesn't stop there. His behavior continues to unravel any remaining support the court may have been willing to extend.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400, so most of these hearings have now resulted in payment. Multiple times the defendant has been ordered to provide job searches to the friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. Currently don't get a electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment for my taxes. I was supposed to get $600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right. So I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero.
Can you listen to me for a second?
No, I'm listening. You guys tell me this every fucking time.
I understand that emotions are running high and frustration is setting in, but this is now the second time you've spoken out of turn. At this point, the patience in the room is wearing thin, and the judge is preparing to issue a final warning. Moments like this are critical because every word and action is being carefully noted. This would be the time to pause, refocus, and listen closely to what the court is saying. The judge's next statement isn't just routine. It's a clear signal that the situation is nearing a breaking point. Ignoring it or reacting impulsively could turn a manageable problem into a much more serious one.
First of all, don't use that kind of language. You're in a courtroom.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. You want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't stop.
No, this is the moment before you end up in custody for contempt. The judge has already shown considerable patience and has repeatedly warned you to rein in your behavior. Despite that, you continued to speak recklessly, seemingly convinced that appearing over a video call placed you beyond real consequences. That assumption is where everything goes wrong. What makes this situation especially unfortunate is that the emotional outburst is completely unnecessary. Yes, you are behind on child support payments, and that fact is not in dispute. Because of that, the court is required by law to move forward with a contempt hearing. However, that step alone does not mean you are guilty or headed for punishment. That a contempt hearing is simply a formal process that gives you the opportunity to present evidence, the same information you attempted to share today. The difference is that it must be done calmly, clearly, and with respect for the court. When handled properly, this hearing can work in your favor. When handled poorly, it creates problems that didn't need to exist in the first place.
Mr. Sylvester, based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got 1 vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you gonna listen, or are you?
Oh, I'm listening. I'm gonna get my shit transferred.
Hey, I get the emotion behind this, but let's strip away the insults and focus on what's really happening here. The situation is spiraling, and the person at the center of it is making choices that are about to land him in serious trouble. He may think others depend on him, but his inability to control himself is pushing him straight toward consequences he could have avoided. What's frustrating is that this isn't just affecting him. His behavior is setting off a chain reaction that's going to impact people who had nothing to do with these decisions. Family members, loved ones, and anyone relying on stability are the ones who end up paying the price when someone refuses to act responsibly. And walking away from the judge or cutting off the court process won't solve anything. Ignoring the authority of the court only makes matters worse and closes doors that were still open. In the end, this kind of impulsive, defiant conduct doesn't prove strength or independence. It only deepens the problems and leaves fewer options for everyone involved.
All right, you just used more inappropriate language, so I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
I'll speak it to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the front of the
how?
court.
You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, or you guys right here. This is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record, and he's talking over me.
Because you guys don't give me a chance.
I'm going to. I gave Mr.
Hey, babe.
All right, everyone. That brings us to the end of today's video. As mentioned earlier, this was a quick and straightforward update meant to get you ready for what's shaping up to be a very eventful week. There's a lot coming, and you won't want to miss the developments ahead. If you found the video helpful or informative, go ahead and leave a like. If it wasn't for you, a dislike is fair too. Either way, be sure to share your thoughts in the comments below, and don't forget to subscribe and turn on notifications so you stay up to date with everything that's coming next.